30 of the Constitution of India. Article 29 Clause 1, Article 29 Clause 2, Article 30 Clause 1, Article 30 Clause 1A. All these clauses of the Constitution, they deal with group rights, cultural and educational rights. They are all not individual rights, except of course Article 29 Clause 2, but they are group rights.
Before dealing with the distinction between Article 29(1) and Article 30 Clause 1, let me look into the scope of Article 29 Clause 1 per se. While construing the scope of Article 29 Clause 1, Supreme Court has emphatically held that the right conferred under Article 29(1) is an absolute one, and therefore it cannot be subject to the restriction in the societal interest like rights enumerated under Article 19(1)A to 19(1)G, read with Article 19 Clause 2 to 19 Clause 6. Article 29 Clause 1 neither controls the scope of Article 30 Clause 1, nor is controlled by that article. In fact, in Jaidev Singh Siddhanti versus Pratap Singh D, AAR 1965 Supreme Court, the appellant in this case, who was declared elected to the House of People, was alleged to have used corrupt practice as prohibited by Section 123, Clause 3 of the Representation of People Act of 1961. The appellant, it was contended on his behalf, was an enemy of Arya Samaj and propagated that respondent was an enemy of Arya Samaj and Hindi language. The High Court accepted the contention and, among other things, set aside the election of the appellant. The Supreme Court unanimously allowed the appeal and set aside the judgment of the Punjab High Court. Justice Shah read Section 123 Clause 3 of the Representation of People Act of 1961 in the light of fundamental rights under Article 29 Clause 1 and observed that the right to conserve language includes the right to agitate for the protection of that language. Hence, political agitation for the conservation and preservation of the protection of the language cannot be considered as corrupt practice within the meaning of Section 123, Clause 3 of the Representation of People Act. Before I deal with the scope, content, and ambit and gamut of Article 29 relevant clauses and Article 30 relevant clauses, let me distinguish between Article 29 Clause 1 and Article 30 Clause 1 of the Constitution. This distinction was expressly mentioned by the Supreme Court in St. Xavier's College case. The distinction between Article 29 Clause 1 and Article 30 Clause 1 is 29(1) basically deals with majority as well as minority. Article 29 Clause 1 of the Constitution says any sections of citizens of India residing in any part of the territory of India having language, script and culture, they have got a fundamental right. Whereas under Article 30 Clause 1, it deals with only minority. Secondly, 29(1), the distinguishing markers are language, script and culture. Whereas under Article 30, Clause 1, minorities must necessarily be based either on religion or language. Thirdly, 29(1) guarantees right to conserve language, script and culture, whereas 30 Clause 1 mandates right to establish and administer educational institutions of their own choice. Right under Article 29(1) may be exercised without establishing educational institutions. But right under Article 30 Clause 1 need not be exercised for conservation of language, script or culture. Lastly, right under Article 29(1) is expressly available only to the group of citizens of India specified therein, whereas it does not appear that Article 30 Clause 1 will be available only to citizens, even non-citizens who are residing within the territory of India, if they happen to be the minority based on religion and language, they will be entitled to invoke that fundamental right. Having distinguished Article 29 Clause 1 and Article 30 Clause 1, let me explain in detail scope and gamut of Article 30 Clause 1. There are a category of cases decided by the Supreme Court with regard to the scope. First case, in Kerala Education Bill, AAR 1958 Supreme Court, where they challenged the constitutional validity of the Kerala Education Bill, which was passed by the Kerala State Legislature. Contention of the petitioners who happened to be the religious minority within the state of Kerala, they said their fundamental right under Article 30 Clause 1 and their fundamental right under Article 26 of the Constitution are violated by Kerala Education Bill. Now this is a reference made to the Supreme Court under Article 143 of the Constitution. There was a preliminary objection raised on behalf of the state of Kerala, saying that it does not involve question of law and therefore it is a bill. Bill has not been converted into an act. It has not been assented to by the government. Therefore, a reference under Article 143 is not maintainable. Supreme Court said Article 143 says question of law or question of fact. Therefore, even if it is a bill, it can ultimately be taken cognizance of under Article 143 of the Constitution. Now, there one technical objection was raised on behalf of the state of Kerala, saying that Article 30 Clause 1 says that there shall be a right. Right is right, every religious or linguistic minority has got a right, ultimately, shall have the right to establish. Shall have the right to establish means it is applicable only to post-constitutional schools and not to pre-constitutional schools. This contention was rightly rejected by the Supreme Court. Supreme Court said whether it is a pre-educational school or a post-educational school, Article 30 Clause 1 must be made applicable. Second contention raised was that this is applicable only to those institutions which have got only students admitted purely and only for minority students. Supreme Court rejected the contention. Supreme Court said that even though students from other communities, other linguistic groups are admitted, you will find the right to establish and right to administer consequently of their own choice. Ultimately, Supreme Court in this particular case, after going through the facts of the case, because the provision of the Kerala Education Bill said that if the conditions mentioned under the Act are not complied with, you will find they will be denied grant, and in appropriate cases, management may be taken over by the state of Kerala. Supreme Court came to the conclusion it violated Article 30 Clause 1 of the Constitution. Second case, Reverend Siddharaj Bai versus State of Gujarat, AIR 1963 Supreme Court, wherein there was training B.Ed college started by Church of North India, a religious minority within the state of Gujarat. They started a B.Ed course because they had a number of primary schools throughout the state of Gujarat, in Bhuj, in Kathiawar, in Rajkot, and throughout the state of Gujarat. But a direction was given by the state of Gujarat that the 70% of the seats in this B.Ed training college must be kept for reservation of the government nominees. Because it was also pointed out that there are a number of government primary schools where dearth of trained teachers ultimately was there. In order to alleviate this problem, they ultimately reserved the seats for 70%. And if the minority institution failed to give effect to this particular instruction, they will be denied grants, you will find, by the state of Gujarat. This was challenged by Reverend Siddharaj Bai, saying that you cannot put restriction in the public interest under Article 30. You can put restriction provided the restrictions are in order to maintain the excellence of an educational institution which belongs to the minority. Since the threat was disaffiliation of the college as well as withholding the grant, Supreme Court said such restriction would violate Article 30 Clause 1 of the Constitution. Then there is a famous case, of course, decided by full bench of the Kerala High Court in 1965, AIR 1965, A.D. Patroni versus State of Kerala. This was with reference to Kerala education rules. Kerala education rules framed under the Kerala Education Act pointed out, ordinarily, the principal of a school shall be the senior most teacher. This was ultimately challenged by principal of the St. Joseph College, Calicut, who appointed a person belonging to Catholic religion, but satisfied the qualifications laid down by the Kerala government and other regulatory bodies. Here, when the senior most teacher challenged the validity of that order before the higher educational authority, higher educational authority accepted the contention raised by senior most teacher who happened to be not from, you will find, Roman Catholic religion. This order given by the higher educational authorities was challenged because it was contended that the tempo of an educational institution, the tenor of an educational institution will depend upon the confidence with which the principal of the school works. So long as the principal of the school satisfy the regulation in terms of qualification, in terms of experience, it should not matter that it ultimately, otherwise, right to administer the educational institution will be affected. Now, Kerala High Court full bench ultimately set aside the order without setting aside the rule, because the rule is not only applicable to minority institutions, but also is applicable to majority institutions. The order was struck down as ultra-virus. Article 13, Clause 1. There is another case, Aziz Basha versus Union of India, AAR 1968 Supreme Court. The question that fell for consideration was the Aligarh Muslim University Act, which was passed by the central legislature before the commencement of the constitution. Certain amendments were made to Aligarh Muslim University Act during 1963, 64, 65, etc., etc. Now, these amendments made by the Parliament ultimately resulted in broadening the scope of court, which is one of the authorities under the Aligarh Muslim University. Earlier, Aligarh Muslim University specifically pointed out only Muslims could be the members of that board. But Parliament amended and said non-Muslims could also be members of it. This was challenged by Aziz Basha, telling that a university is an educational institution within the meaning of Article 30. But Supreme Court rejected the contention. Supreme Court said whatever may be the history with regard to establishment of Aligarh Muslim University, Aligarh Muslim University is incorporated under the main University Act by Parliament, and therefore you cannot contend that it is a minority institution which can invoke Article 30, Clause 1 of the Constitution. In Reverend Father Proust versus State of Bihar, 1969 Supreme Court, there was a section in the Bihar University Act which provided for University Service Commission. The duty of the University Commission is to conduct exam and interview and keep a panel of the teachers. And from this panel, recommended by the University Commission, teachers of the affiliated college must be selected. This was with reference to St. Xavier's College, if I am not mistaken, in Ranchi at that time, where they appointed teachers with relevant qualification and experience, but they appointed not from the panel, outside the panel, you will find, according to the discretion of the religious minority which established and managed that particular college. The contention was Section 45A, subject to correction. It violated Article 30, Clause 1. Supreme Court, echoing the decision of the Kerala High Court in A.D. Pathodi versus State of Kerala, pointed out that teachers ultimately the future of the institution, the coronation of an institution, and the triumph of that educational institution depends upon the teachers. So long as the teachers satisfy the basic qualification and experience, whom to appoint is not to be ultimately interfered with as far as the minority educational institutions are concerned. As a student of constitutional law, I must admit that the Supreme Court has been strictly interpreting scope of Article 13, Clause 1 from 1926 January 1950 up to 1974. But from 1974 onwards, Supreme Court has been trying to interpret, you will find the scope of Article 30, Clause 1 of the Constitution. As regards the right of the minority, you will find in a liberal way. Because Supreme Court, Justice Das pointed out, right to administer does not mean right to maladminister. So that change came in Gandhi 510 College versus Agra University, reported in 1975 Supreme Court. Question that fell for consideration was that the Agra University said every affiliated college, whether belonging to the minority or not, they must constitute a local managing committee. Now, in the local managing committee, apart from those who have established, those who have promoted that particular college, the university insisted, principal of the college, as well as senior most head of the department of the college, should also be ex officio members. This was challenged by this Muslim educational college belonging to the minority, contending right to administer is violated because principal of the college, the senior most head of the department of the college are made the members. Majority of the members of the particular committee still continue to be those who are selected by the promoter or the founder of the minority college. Only these two persons were there out of 10. Therefore, just as we have pointed out, that this is innocuous, this is innocent. And not only that, assuming for the sake of argument, there are problems afflicting academic, non-academic issues of the college. It is the principal and the heads of the department who are acquainted with the problems of the college on a daily basis. Therefore, these two, because there was a threat, if these appointments are not made in accordance with the provisions of the Agra University Act, the college will be disaffiliated. The relevant operative provision of the particular section was upheld by no less than Justice B.R. Krishnan. Now, there are other problems. For example, there is a famous case, Frank Anthony Public School Employees Association versus Union of India. Now, this is a case not filed by the minority institution, but the employees working in the minority institution. Section 12 of the Delhi School Act of 1973 exempted the minority educational institutions from code of conduct, proceedings of the disciplinary proceeding, imposition of penalty, scale of pay and allowances, constitution of the tribunal for appeal. So this was not applicable. Therefore, salaries paid to the minority school were less than the salaries paid to non-minority schools. So they challenged, you will find, because section 12 was made inapplicable to the minority institution, and the constitutional validity, or you will find, of this particular section of exemption was challenged on the ground that there is an absence of parity, and especially under Article 14 of the Constitution. Taking the clue from Patroni versus State of Kerala High Court, and also taking the clue you will find from Government of Trust versus State of Bihar on a different fact. The contention of the Employees Association was a contented teaching staff is essential for maintaining excellence in educational institutions. This was upheld by Justice Chinnappa Reddy. Most of the provisions, including the particular provision pertaining to the scale of pay and allowances, if scale of pay and allowances are not made applicable, you will not get a contented teaching board. And if a contented teaching staff is not available, then the excellence in the educational institution may be badly impaired. And therefore, contention of the Employees Association was as well. There was a threat even by the management of the Frank Anthony Public School Association, saying that we may close down the educational institution. Supreme Court rejected and said, we are not worried about this particular threat unless and until scale of pay of the employees of the minority schools are equal to whom Article 30 Clause 1 is not applicable, we will find Article 14 will be affected, and therefore contention of the Employees Association was upheld in Frank Anthony Public School Employees Association versus Union of India. Now there is another case, because there was a case decided by the Madras High Court a couple of years ago. with regard to SIET, a South Indian Educational Trust college was there in Chennai. A notification was issued saying that Compulsory Vacancies Act, minority institutions should set the information as required by Department of Employment, Government of Madras. This was not done, and the minority educational institution challenged the constitutional validity of the action of the Madras government as ultra-virus, Article 13, Clause 1. We are not compelled to follow that law. The single judge of the Madras High Court upheld that particular contention. But in CMC, Hospital Employees Association versus CMC Vellore, AAR, 1988 Supreme Court, the question that fell for consideration before the Supreme Court on appeal was whether Section 11A, Section 12, Section 33 of the Industrial Dispute Act of 1947 are applicable to minority educational institutions. Supreme Court held, you will find by liberally interpreting that the general law of the land is applicable. Here is a beneficial legislation which takes into account ultimately the welfare of the employees. So, merely following, giving effect to the welfare employee law cannot be said to affect right of the management to administer the educational institution of the charge. There was another case in 19, St. Stephen College, New Delhi versus University of Delhi. The University of Delhi issued a circular saying that every affiliated or a constituent college of University of Delhi should admit the students on the basis of the marks which have been received by them in the qualifying examination. But St. Stephen College did not give effect to the circular contending we are holding interview, and on the basis of interview, if you are not permitted ultimately to admit the student on the basis of interview, which we have done for a long period of years, it will affect our right to manage the affairs of the institution. Supreme Court said, interview, if it is held fairly, objective, and with transparency, it could be a valid test for admission. University instruction to admit only on the basis of marks obtained at the qualifying examination is violating of Article 30 Clause 1 of the Constitution. And in this particular case, Supreme Court also pointed out that in a minority educational institution, whether based on language, whether based on religion, you should admit 50% of, you will find the student belonging to that minority. A quota was ultimately fixed, you will find in this particular case. The entire scope of Article 30 Clause 1 was looked into by 11-judge bench decision in familiarly known as TMA Pai Foundation versus State of Karnataka, AAR 2003. Now, TMA Pai Foundation case, it partly overruled Unnikrishnan's case as well as St. Stephen John's case. In St. Stephen John's case, the Supreme Court said 50% of the seats must be reserved for admission for minority and the rest may be non-minorities. But Supreme Court said, partially overruling in DMA 5's case, that reservation must be reasonable. Now, what is reasonable reservation for minority educational institution depends upon the type of education, the educational needs of the locality, and ultimately educational situation in a particular country. So all these relevant factors we have to say, to that extent it has been overruled. Secondly, TMA case seems to suggest, under specified circumstances, the right of the minorities under Article 30, Clause 1 may be restricted in the interest of general public, a proposition which was not permitted by the Supreme Court in Reverend Siddharaj versus State of Kerala, or for that matter, St. Xavier's College versus State of Gujarat. Now, there is another important epoch-making decision given by the Supreme Court, Islamic Academy of Education versus State of Karnataka. Justice Kare, CJ and Kapadia directed in this particular case setting up of two committees in each state. Committee 1 will have to give effect to the judgment of TMA Pai's case and approve fee structure charged by the minority institution. So therefore, what should be the fees? It should be decided by the committee consisting of retired judges of the High Court. And Committee 2 will look into oversee the test conducted by the institution, which means test to be conducted by the institution, minority institution, must be transparent, fair and objective. Thirdly, fixation of the state quota for admission in respect of unaided professional institution. Because the question was asked whether educational institutions under Article 30 Clause 1, whether it will involve university. They said yes, because there was a question that the minority educational institution, while admitting the students, they need not be bothered about the language, script and the culture mentioned under 29 Clause 1. What is important is, even a professional educational institution can be started so long as the institution is established by the minority, either belonging to the religion or language. They have got a right to admission. And the Supreme Court emphasized always of their own choice. And that was insisted in the beginning. Later on, Supreme Court took a very liberal stand. In St. John's Teachers Training Institute for Women versus State of Tamil Nadu, AIR 1994 Supreme Court. Supreme Court has successfully and succinctly summarized the following broad proposition from the catena of cases previously decided by the Supreme Court relating to the scope and content of Article 30 Clause 1 of the Indian Constitution. First, fundamental rights declared by Article 30 Clause 1 is in absolute terms, but subject to certain regulating measures. 2. There is no fundamental right under Article 19(1)(g) to establish or to administer an educational institution if recognition is sought therefore. 3. There is no fundamental right to recognition, and any educational institution seeking recognition should abide by the regulation framed and prescribed by the state as condition therefore. 4. Educational institutions of minorities to invoke the benefits of Article 30 Clause 1 must be in truth and reality, a real minority institution. It should not be mere masked phantoms. 5. Minority institutions must be fully equipped with educational excellence to keep step with other institutions in other states. 6. Regulation framed by the state cannot abridge the fundamental right of the minorities, and should be any restriction which are put on the minority institution should be in the interest of minority educational institution and not based on state necessity or general societal interest. But this particular proposition is subject to TMA 5 Foundation case, in which majority of the 9 judges came to the conclusion that the right of the minorities under Article 13 Clause 1 may in appropriate cases may be restricted in public interest. 7. Regulation should be made with a view to promoting excellence in educational standards and ensuring the security of the service of the teachers and other employees of the institution. And further, in the true interest of efficiency, discipline, health, sanitation, morality, public order, and the like. 8. Even unaided educational institutions are not immune from operation of general law of the land, such as contract law, tax measures, social welfare legislation, labor and other industry laws, and other laws which are intended to meet the needs of the society. If these general laws are applicable to unaided educational institution, there is no doubt it will be applied to the minority educational institution which are getting grant and are protected within the meaning of Article 30, Clause 1. Now, there is a provision in the Constitution, Article 30, Clause 1e, which was an addition to Article 30, Clause 1. Of course, 30, Clause 2 says that the government shall not deny grant to any educational institution belonging to the religious or linguistic minority on the ground of religion, or for that matter, on the ground of language. The scope of Article 30, Clause 1e categorically says is that whenever the state is acquiring a property or requisitioning the property, that acquisition or requisition of the property must be done in such a way, compensation is paid in such a way which will not impair the right of the minority available under Article 30, Clause 1. The entire scope of Article 30, Clause 1a is inserted by the Constitutional Amendment was considered in Society for St. Joseph's College versus Union of India, AAR, 2002 Supreme Court. The question that fell for consideration was one of the part of the building and the place in which the St. Joseph's College Tiruchirappalli was situated was sought to be acquired by the appropriate government. This was resisted. You will find in a series of cases by St. Joseph's College saying that it affected the right under Article 30, Clause 1a. The question that fell for consideration before the Supreme Court was whether the acquisition could be done under the existing law, namely Land Acquisition Act, or the law which was in existence before this amendment was introduced. Supreme Court came to the conclusion a separate law apart from Land Acquisition Act is required because the compensation or amount to be paid in the case of immovable property belonging to minority institution should not impair, should not restrict, and should not abrogate the right available to them under Article 30, Clause 1 of the Constitution. Here, incidentally, I may observe, even though Article 31 was omitted by 44th Constitutional Amendment, and the fundamental right under Article 30 Clause 1 was made a constitutional right under Article 300A. You will find there are places under the fundamental rights chapter where right to acquisition or right to requisition still exists. This may be taken note of. For example, under Article 26, Clause C and D, the religious denomination may acquire immovable property in accordance with law. This is one right which is available. Then, Clause 2 of Article 30, Clause 1A categorically pointed out that if the property to be acquired under Proviso 2 to Article 30, Clause 1A is within the limits of the Land Reforms Act, the owner of that property must be paid just equivalent market value of the property. So there are provisions in the Constitution. For example, Article 21 may be considered as an unarticulated right. Right to acquire, dispose, hold property under Article 91. That has been omitted. The question comes whether that right to property can be found under Article 21 of the Constitution. So therefore, this is, according to me, the substance, essence, and the quintessence of scope of rights of the minorities to administer the educational institution under Article 30, Clause 1. Now, I may conclude. There are three clauses under Article 30, Clause 1. One is right to establish. Right to establish means right to bring into existence, right to commence an educational institution. This is number one. Secondly, once that institution is established, brought into existence by religious or linguistic minority, it has got the right to administer. And that administration is done of their own choice. Now, these three ingredients were strictly, you will find, looked into by the Supreme Court, without looking into the public interest, without looking into the problem affecting the employees working in the educational institution, whether as a teacher or not teaching staff. Now the Supreme Court has harmoniously construed these rights. You will find giving effect to the observation made by Justice Das that right to administer does not mean right to not administer. Thank you.